to Jackie for a divorce and they bring their girlfriend in with them to talk about the divorce, they waive the privilege because now they're giving information out
to a third party.
Yeah, there's a third party present that hears confidential information.
When there is some conflict or some pangs of conscience that you as lawyers have, where do you turn apart from to each other for perhaps some feedback? Is there is it the disciplinary counsel that you go to first?
Yeah, you have. Well, first, I think you need to look up the rule more be more familiar with it. Sometimes lawyers tend to look to other attorneys just to get some idea as to what their thoughts would be. But ultimately, we do have, as David said, the Supreme Court employs an individual who's an attorney. Matter of fact, there are two attorneys there.
Yeah, there's an office.
It's the Office of Disciplinary Counsel in Rhode Island. In Massachusetts, it's called the Board of Bar Overseers. Those are the police. Those are the police. And anytime there is a disciplinary issue, that's who hears it. So the last thing a lawyer wants to see in their mailbox is something from the Board of Bar Overseers and the disciplinary counsel.
Even if it's a friendly letter to say, hello, just want some information
on
somebody else. The letterhead comes in, the envelope with that little seal on it, and you say, I never did anything wrong. Why am I getting this as you open the envelope? But what Jackie was saying is 100% right. The first step we always do when any ethical issue comes up is we talk to each other, like you said, and we get the rules out and we look at them. For example, another lawyer refers a case to us that we work on. Can we share a fee? Is that ethical? It doesn't cost the client any more money, but are you allowed to give what we call a referral fee? Well, what did we do?
Look up the rule.
We got the rule out, we looked on it. And what the rule said is as long as the attorneys from different firms share responsibility for the client's case, and as long as the client's informed of it and understands and agrees to it, it's fine. So what we then did, and as a result of that, is we created a form that says to the client, this is the rule, where, as you know, you were referred by your friend who sent you in for this case. We will share that fee with that person. It will not cost you anything more, and we're disclosing it to you, so please sign and authorize that that's okay. You follow the rules, and that's how you do things as attorneys. Now, if it came to a question that was more difficult, we will often pick up the phone just like that other attorney did and call and say, what's the deal here?
Yeah, is that without consequence or recrimination for you if you just called for the query?
Yeah, as a matter of fact, personally, I did it about 3 or 4 months ago. I had an issue that came up in the office, and a red flag went up, and it wasn't something that I did personally. It's something that happened with a third party, and I just called the disciplinary counsel and I said, you know, I think I have an obligation to disclose this because I know that there is a wrong here. And he said, you're absolutely right, and if you didn't disclose it and you know about it, then we can be disciplined.
And you're culpable, okay.
And this is a situation where
that's what I did.
Jackie may be aware another attorney has breached their ethical responsibilities. They violated the Code of Professional Responsibility. As officers of the court, she's saying we have a duty to disclose that. The other thing is, when you say, will it keep you out of trouble, what you do is you report or ask if it's something that you want to know for yourself before you undertake the action or the activity.
You have the clearance that way. What happens now, as we were speaking about this case, and it was 2 individuals and what was happening, one being in jail, what about corporations? I'm not sure that many people have much sympathy for something like an Enron corporation. Bad company, they should be punished. However, the lawyer who's representing them has some responsibility. Suppose he was told about some of their wrongs. What's the confidential communication rules there? Is that still attorney-client privilege that's supposed to be sacrosanct?
Yeah, same thing. We as lawyers, if we were prosecuting Enron, we are prohibited ethically from communicating with the defendant and/or its agents. Now, the rule as to employers or corporations is the higher the person is on the management level, the more likelihood is that you have the attorney-client privilege. If I'm communicating with somebody who is just, a low-level employee, I even hate to call it that, but for instance, like a bank teller versus the president or CEO of a bank, then you're not really breaching your obligation.
So if that bank teller can forward to tell you something that was directly bearing on that case, you are not obliged to hold that in confidence?
Well,
if it's
we're
against
talking
that?
about two different things.
Okay.
First thing we're talking
Clear.
about, and let's just, I like to take a step back, I'm a back stepper, is a corporation legally is its own individual, it's got its own identity, a separate identity. So the law treats the corporation much like you would treat a person. So if you have information as the attorney for the corporation, there's attorney-client privilege. Absolutely exists. What Jackie was talking about is, if she was saying if we're suing that corporation, we can't call the corporation up and say, tell us information about this case.
Yes.
We have to go through their attorney.
That's right.
If someone who worked there called us up and they were the bank president, if we're suing a bank, we can't talk to them. If the teller calls us up and says, you need to know what's going on here, you can do that. Again, I'll go back to a movie example. It was a civil action. Do you remember that movie?
Yeah, I do
The
remember.
polluting of the wells in Woburn,
Yes.
Mass. And in there, someone who worked at the tannery, I believe it was, came to the attorney and said, this is what's been going on here. You need to know this, this, and this. And, you know, they were able to use that information. Same thing in that movie, Aaron Brockovich. The person
Yes.
had information.
Low level.
Low level. If they could not communicate directly with a higher up in the corporation, that would violate the rules of
We've
ethics.
actually seen that in our practice. I think you did personally with a case that settled a long time ago where someone was communicating with our client.
Yeah, now this is actually,
A counsel from
right,
the other side was
right.
communicating with our client.
which is a clear breach of ethics. And what happened, and here's why that's a problem. The client then told her attorney, I was helping her attorney, that she was afraid to testify. So he said, well, what do you mean you're afraid to testify? You know, I prepped you for the case. She said, well, I've been talking to the other attorney's office without you knowing it, and I've told them secrets about my life that I'm afraid they may use against me. And now that through that whole trial into a
It
mess,
imploded.
it imploded, and the judge had to refer the attorney to the disciplinary counsel for an
The
investigation.
reason for that is because we as lawyers now have an obligation to let the judge know that there was a breach and it's going to affect the outcome of the trial.
Right.
And then as David goes further, the judge then had to make the
call.
call.
This sort of opens up the wider topic
Yeah.
of your code of conduct, and some make jokes about their lack of conduct or code of conduct. But you have one. It says you're supposed to adhere to a high ethical code, and also among your own peers.
Exactly.
What happens when you have discovered or uncovered that there's a problem with another lawyer? Is that a disciplinary action? Are you required to do that? Do you keep that person's counsel even though it's not an attorney-client privilege? Are you obliged to come forward because of your own code of conduct?
Yes, absolutely.
Absolutely.
If you know that someone is prosecuting a case in bad faith, the example I gave you before, if you know an attorney is committing a wrong or stealing money or something like that, that's what you hear about more often now,
Right.
is attorneys losing their license because they're using their client's money without their consent.
Right, and I've seen cases, I should say read about cases, where there's an attorney who gets disbarred because he improperly takes clients' money, and another attorney who got in trouble, not that he did anything actively involved with that, but knew about it and didn't report it.
Explore that a little bit, if you will. Most are familiar with giving lawyers retainers or work money so that they can do work on their behalf. That's usually an escrow.
Not always.
Not
no.
always.
You
When
gotta
is it-
look
when is it
to-
not?
What's the fee
What's
agreement?
the fee agreement? So
Okay.
anybody that goes to a lawyer, you need to have something in writing as to what your fees are going to cover. Is it going to be one flat fee for maybe 5 hours worth of work? Everything has to be confined to a
Right.
writing so that the client understands fully what they're paying for and how they're paying for it. If it's an hourly fee, then yes, we
Put it in
again, you
escrow.
put it in escrow, and it's not earned by us until we actually do the work and bill the client. And we can only take out of that fee the same amount equivalent to the hours of work.
And here's the ethical rules, the rules of professional conduct require a contingent fee agreement.
That's right.
when you get paid on contingent upon